Welcome to the Arbitration Conversation. So in this webisode, we are going to be talking to Professor Victoria Sahani. Professor Sahani, she's an expert in investment treaty arbitration, but she's also a professor at the University of Arizona, or Arizona State Sandra Day O'Connor College of Law. But she's also the director of the Faculty Inclusion Research for System Transformation Initiative, or FIRST Initiative, which is a really great, really cool thing she's doing with the university there. But she's also the Associate Dean of Faculty Development as well. And again, as I said, she's a true leader and expert in the area of investment treaty arbitration. So first of all, Victoria, you're so accomplished. I'm just very, very grateful that you took the time to talk with us today. Thank you.
Thank you so much, Professor Schmitz, for inviting me to speak with you. I'm excited to have our conversation.
Okay, cool. Well, let's jump right in. I guess to start off with, could you just give a little bit of background about how you even got involved in investment treaty arbitration?
Sure, absolutely. So I always had an interest in international dispute resolution, even when I was in college. It's part of the reason I went to law school. And after a brief stint at a law firm, I worked in real estate for about a year, but I was always looking for an international dispute resolution opportunity. There was an opening at the International Chamber of Commerce, or ICC, in their North America office for their Court of Arbitration. They were looking for a Deputy Director of Arbitration and ADR for North America. And I applied, interviewed, and was fortunate enough to be selected for that position. And so that began my journey. So the International Court of Arbitration, as part of the ICC, is one of the oldest international arbitration institutions in the world. The ICC was founded in 1919. The court was founded in 1923. So it's coming up on its 100th anniversary in a little bit. And basically it was founded to handle commercial disputes. It was actually founded after World War I by people who called themselves the Merchants of Peace. And the idea was, let's have commerce, let's have trade, and let's have peaceful resolution of disputes that come out of that commerce and trade, and that will help us prevent war in the future. So that was the idea. And so over time, while I was there at the ICC for about 5 years, the ICC actually started to see an uptick in what are called investment treaty arbitrations. So it's normal, sort of bread and butter, normal cases that it gets would be commercial. So business A versus business B. But you started to see these cases where you'd have, business A versus country B or something like that. And so, I started to look into these further, and it turns out that these types of cases proceed under what are called investment treaties. And so, so this is slightly different than a commercial case. It's basically a situation in which a corporation is an investor in the territory of a country, usually called a host state. And that investor will usually have some sort of physical infrastructure or something that they've built in the country, like if they're doing water treatment plants or natural resource extraction or something like that, they will have some plant or factory or something. And they may either lose that because the government takes it over, or the government may regulate it in such a way that it's not profitable anymore. And then based upon a variety of different parameters, they can sue the government. So that is essentially how this works. People who are listening may have heard of foreign direct investment or free trade agreements and things like that. That's what we're talking about. That's the type of investment we're talking about. And most of those treaties that are those free trade agreements and things have arbitration in them, and that's investment treaty arbitration.
Well, let me ask you just sort of, just to clarify, one question comes up. So does that mean that when we're talking about investment treaty arbitration, you're always going to have a state, a government as one of the parties, or sometimes could it also be two private parties?
Mm-hmm. Yeah, so investment treaty arbitration will always have a state as a party, and more than that, the state will always be the respondent. And that's what meant one of the reasons it's unusual. And you might ask, well, why is that? Well, part of the reason is that the way the treaties are formulated is to give the investors rights and protections. And it's to try to induce them to invest in a territory of the host state. That's what we call the state. They're hosting some company to come in and build something or improve their infrastructure or whatever it is. And so in order to attract those companies, the countries enter into these treaties with other countries to say, here, send your investors our way. And if they come our way, we will give them all these benefits. Maybe we'll relieve them from tax laws or whatever it is we might do. And in addition, if they have a dispute with us, we will submit ourselves, the sovereign state that we are, to arbitration. And the arbitrators in the instance are private individuals that are selected by the state and selected by the investor. But that it's unusual in that respect. And that's under the treaty. So it's essentially an open invitation to arbitrate. And then the investor accepts that invitation by filing the arbitration.
So I guess the question then, I mean, I'm guessing already, considering you have public entities involved, why is it that investment treaty arbitration has become fairly controversial in recent years, especially?
Yeah, so you can imagine that investment treaty arbitration, anything involving states, becomes political. So that's number one. Number two, one of the challenges of investment treaty arbitration is that the nature of the world in which it was created is different from the nature of the world in which we now find ourselves. Investment treaty arbitration, for all practical purposes, started, or at least it really began its roots in 1965 when several countries entered into what's called the ICSID Treaty. ICSID stands for the International Center for Settlement of Investment Disputes. That treaty is part or created an arm of the World Bank, which was a lending institution, created part of the World Bank to resolve disputes between investors and states, host states. And so that regime, when it was created in 1965, they sort of thought, we'll have a few countries involved in this, and this might help improve trade. Over the years, the investment treaties that came out of that ICSID treaty, so you have the ICSID treaty that has sort of a procedure, but then you have to have individual investment treaties between nation A and nation B, or a multitude of nations, like NAFTA had 3, which is now USMCA, but has 3 nations. The Energy Charter Treaty has multiple, that also has arbitration, so things like that. And so you have this proliferation, of other treaties over the years, but still, you didn't have a lot of cases. And part of the reason for that was, I think, and there's a lot of conjecture out there, but part of the reason for that, I think, is that the capital was flowing one way. You had sort of developed country investing in developing country, or investors from developed country investing in developing countries, and it was kind of a one-way thing. Now it's actually going a little bit of 2 ways, right? There's some countries that used to be thought of as developing that actually have companies that are investing in, say, more developed countries like the US and others. And so now you have this sort of 2-way flow. And what's happening is those countries that previously signed these treaties, decades ago, when they had less political power and less money, they're like, wait a minute, this is not really as fair to a country in our position as you would imagine, and so as we would want it to be if we had more political power. And so many of them don't like the system anymore, or they're challenging the structure of the system. And that's also because more cases are happening. So in the past 20 years, maybe if you go into the 90s a little bit, you start to get an explosion of cases. And now there's hundreds and hundreds of these cases. Excuse me. And so that also put a big spotlight on the system, because previously it was sort of this one-off thing that wasn't used very often, but now there's more states involved, more cases, more of them being sued. So now they're saying, okay, we need to look at this and maybe reform this system.
Well, and that really brings me to the next question, because I can see exactly what you're saying, and I've seen that in the literature as well, this kind of rise in cases and the spotlight on perhaps structural unfairness. What do you see as reforms? I mean, what do you kind of see coming down the pipe? Do you think that there will be reforms in the near future?
Yes, absolutely, definitely there will be reforms. So I'll start with what's concrete, and then we can move to something a little more abstract. So concretely, ICSID itself is revising its rules right now as we speak. They've been going through multiple rounds of edits, but they are in the process of revising and modernizing their rules and trying to create some provisions or add provisions in that I think would help balance things a little bit. The biggest issue well, one of the biggest issues is jurisdiction. States say, look, we know we're supposed to be respondents here, but we should at least be able to bring counterclaims if the investor, say, is polluting our environment or mistreating our local workers or something. And the treaties the old treaties don't provide for rights for the states so that they can bring counterclaims. It only provides rights for the investors. And so the argument in the past has been the arbitral tribunals don't have jurisdiction if a state brings a counterclaim. But I think that our argument is crumbling, partly because it's the state that created the system. The states had to enter into the treaty to create the system. If the states say, this is something where we should be able to bring a counterclaim, then they can change the system to make it so. In addition, I think more states are getting involved in commercial arbitration. So they're used to that bilateral, claimant respondent plus counterclaims on both sides. And so they want to make investment arbitration more similar. So I think that's coming. And there's been a few newer treaties that have been entered into that actually have an ability for states to bring claims, sometimes in investment arbitration, but more often the states actually want to bring the claims in their home courts. So that's often what the treaties will provide for. So that's sort of a more concrete, so that's coming. What's being talked about is perhaps having some sort of appeal body. So the way investment treaty arbitration works right now, and commercial arbitration as well, is the idea that it's final and binding. Like you get one shot at it, and whoever wins, whoever loses, that's it, right? Unless there's some procedural defect where you can challenge the validity of the award. Okay, so in ICSID case, well, the way it works right now is they do have one level of review, and it's called an annulment body. The annulment body, as its name suggests, is not an appeal. All it can do is say this award is valid or this award is invalid. So it can either approve the award or it can invalidate it completely. It's not really an appeal. They don't change the decision of the lower or the tribunal, the arbitral tribunal. And so a lot of states are dissatisfied with that. They actually want a true appeal. So there's been discussion of perhaps creating an appellate body for ICSID, which would be revolutionary because there is no arbitration system that currently exists that has an appeal, because the whole point is it's final and binding.
Right.
And so I don't know. I mean, there's some people that really are proponents of that idea. There are other people that really oppose it. And so it's being debated, hotly debated. But a lot of states they really like the idea because they're used to judges, they're used to judicial systems, and it makes them feel more comfortable. So we will see, but that would be a huge change if they adopt that. So let's see what happens.
The last thing I wonder, because looking at the Singapore Convention and the questions about bringing more mediation into investment treaty disputes, do you see that as also being promising, or do you have concerns with that?
Well, I actually think it's quite promising, partly because there's something similar actually built into the ICSID Convention. So ICSID has a conciliation provision, which people don't really hear much about that one, but it's there. And it is used. It's not used as frequently as the arbitration provisions, but it is used. And for those who may not know what conciliation is, or at least in the ICSID context, it's essentially a formalized form of mediation. Imagine a sort of a mediation with a stricter protocol than you may be used to. But it is mediation. The conciliator does not decide the case, but there are conciliation rules that ICSID has. And so I think that because that system exists, I think states are familiar with the idea of a mediation or conciliation type process. And they like the idea also, I think, because then they can bring in their politics, their diplomacy. It's not sort of a judge or adjudicative process with an arbitrator. So I actually think the Singapore Convention could be very promising. The issue with the Singapore Convention is adoption, right? We need more states to adopt it. We need more states to ratify it in order for it to take effect. And then you kind of need a critical mass of states in order for it to become viable for something like investment arbitration. The ICSID treaty has 160 some odd parties. And the Singapore Convention is not nearly there yet. So I think that's one of the challenges, but I could see it in the future.
Yeah, maybe, in allowing for different interests and maybe some more creative problem solving techniques than arbitration. Yeah. But overall, just really interesting stuff. So thank you. Thank you for explaining. I think you just really did a fantastic job of explaining the difference between investment treaty and commercial arbitration, but also for us to really think about why it's important, especially in this moment, as things become, as you said, more of a two-way street. And you have a lot of different issues that are bound up within these questions. So thank you so much for taking this time. And I really hope you have a great rest of your day.
You too. Thank you for having me.